has something to take notes with. All right, we got 68 people joined up with us today. I'm looking for, let's see, gallery. Where's everybody?
I got a question for you.
Carlos is here. Okay, who's speaking right now?
Donna,
Okay.
where did you get the Department and Chapter Service Officer Certificate Training Program Level 2
Okay.
pamphlet?
So I sent out an email to everybody that registered yesterday. If you don't have the PDFs, definitely check your emails for, I'll tell you what to look for right now.
Okay, well, I was sent one earlier and I signed up for today, but I also left you an email message yesterday that I attended yesterday's training.
Okay,
And I don't know if you got that or not.
I did. So I did get that. I just want to send out, I want to make sure I sent out PowerPoints, and it looks like I sent out the PowerPoints yesterday. So long story short, right now, Donna, you're on the webinar panelist, and nobody else can ask that. But I did send that out, and it's a good question because I believe other people who are listening who can't speak up right now may have that same question.
Okay.
Department and Chapter Service Officer Training Certificate Training Program, Level 2, again, there's a PDF that is in your email. However, you don't need to pull that up right now because the NSO team will be going through this in person with you right now. So I just suggest that everybody have something to take notes with. Just like yesterday, if you're participating, please write all your questions and answers into the Q&A section. And the NSO team will go through all your questions in real time or save the questions that matter to everyone and answer those to the big general population. So
Okay, so do I need to put this question on there or?
Yeah, go ahead and write your question, and I'll go back around and I'll send people the files if they need me to send it directly to them. But before we kick off, we got chats. Okay, so long story short, let's go ahead and spotlight Jim and his team. And if there are any questions that are not pertaining to CSO training, email me directly. I'll put my email in the chat room.
You could also find his training in the membership portal. They'll have the service officer guide and these PDF training.
Yeah, and this NSOs can walk you on how to find that stuff right now. So we're good to go. Go ahead and spotlight the team, Enrique. And if there are any questions, again, share those questions in the Q&A section, and we'll tap into you.
All right, hello everybody. Good afternoon. Hope you guys had a good lunch. My name is Carlos Gallardo, and I'll be instructing you in this first portion of the Department and Chapter Service Officer Certification Program Level 2. Can everybody hear me?
Yes.
Okay. Can everybody see the training guide?
No.
Hey, Enriquez, this is Michael Silver. You're echoing. So I just want to let you know that.
Okay. So you guys can't see the guide?
We can see the guide, Carlos.
Okay. Do I sound echoey? I can change rooms.
Yeah, you do.
Yes, but
Okay. Give me a second. Okay, how do I sound now?
like God's child.
You're good, buddy. You're good.
All right. Something from my backyard. right, so let's go ahead and kick this off. Welcome, everybody. If you guys have questions against pertaining to this, go ahead and put them up there. I'll try to answer them as we go along, if possible. But if not, I'll definitely answer the questions towards the end of my portion, okay? So let's get this started. Okay, so this is what we're going to be discussing today. DSO, CSO mission and responsibilities, the principles of service connection, evidence and effective dates, standardized forms and FDCs, which stands for fully developed claims, Appeals Modernization Act, DBQs, VA exams and combined ratings, service connection for PTSD, military sexual trauma, suicide prevention, mission act, community care, and then we'll review the service officer's guide. So, missions and responsibilities. Okay, the mission and purpose of the DSO and CSO is mainly to gather information and assist in obtaining benefits for the veterans and their dependents and survivors. Okay, we understand your training may be limited, so always ask questions. If you aren't sure, always direct the claimant to the National Service Office or call us. That's what we're there for. Call your local jurisdiction office so that we can provide you with information regarding what the veteran should take. Always remember, never submit information directly to the VA. Always use your National Service Office to funnel that information. All right, certification scope and def. Go ahead.
Hey, and one reason for that is the VA is your friend. So one thing that we're tasked with doing is maintaining what you have. So you might have a good day where you were medicated and you were evaluated. So that last examination doesn't reflect the overall true you. So bring it in so they can review it before the VA gets their hands on. Sorry for that, Carlos.
Thank you, Lee. Okay, so moving on, certification means that DSOs and CSOs are covered by DEV's liability insurance, requires annual training and certification, and ensures that claimants receive accurate VA benefits, assistance, and information. Okay, the accredited representatives, NSOs, have received accreditation by the VA, so we are the only ones that are accredited through the VA. DSOs and CSOs are not. The legal environment of claims-related service work publication, maintaining privacy, ethics, and conduct. You may not accept gifts. And just to reiterate, this information might sound redundant from yesterday. This is just a more in-depth, and we'll be going in more in-depth into the topics that we hit yesterday, just so you guys are aware, okay? Ethics and conduct. You may not accept gifts, money, or favors for any services provided as a DSO and CSO. Somebody yesterday asked about, well, what if I'm a notary? Can I, charge for my services? Well, in reality, no. You're a volunteer. Unless you're a DSO, you might be a paid employee. But CSOs, I believe, are volunteers, and you should not be accepting any money. And most paperwork from the VA, it does not need to be notarized anyways. And you will be held personally liable for any misconduct not in compliance with DAV policies and claims related to standard service standards. Representation, DAV representation. The form that's used for representation is VA Form 21-22. Appointment of Veteran Service Organization as claimant's representative. We call it a POA, or power of attorney. Okay, we will review this form more in depth in a few slides. This form is important to be completed properly as it's constantly changing. We always ask that you use the forms from the va.gov website. That's where you're going to get the most up-to-date forms. So don't ever Google it. Just go to va.gov, search VA forms, and then it'll take you to the va.gov website and pull it from there. there's certain parts of that form. So I'll go ahead and go to the form so you guys can see it here. Parts of the form are only filled out by the service officer. Okay, that's mainly section 3 down here at the bottom, where you guys can see where it says leave blank. That's where our organization name goes, the actual national service officer, the service officer's email. That's where all that information goes. So we'll fill that out. The only part that the veteran or that you can assist with filling out is section 1 and section 2 if needed. Well, section 1 is needed, I should say. On the back of that form, okay, it's important that they check off box 19. If that box is left blank, we will not accept that power of attorney. I'm sorry, did I hear somebody? Okay, sorry. We will not accept that representation form if that box is left blank. And also, if they give us any limitations on box 20, we will also not accept that representation form, because in essence, they're giving us limitations, and with limitations, we're unable to see their entire files. So make sure that box 19 is marked off and that box 20 does not have any limitations of consent. Box 21 can be left blank, it's fine, it's their option. And then just make sure that they sign it. A lot of times we get forms done at the office and the veteran didn't sign it. And therefore, there's nothing we can do with that form. But please make sure that they sign it so it avoids having to have the veteran redo it or resend it. And then leave the veteran service organization part blank, as that's where we as a service officer, and if I'm not mistaken, I believe DSOs can also sign if you have been certified for this training. I believe you can sign those as well. If you're going to take a power of attorney and the veteran is not ready to file a claim, please make sure that you submit an intent to file form. That's VA form 21-0966. It should be completed for any person that's never filed a claim before in the past, or for any claim that has not been previously submitted. Even if they mention the thought of, yeah, I think I might file down the line, submit it just to protect them and to protect DAV. Remember that intent to files, and I'll go back over here just so you guys can see where I'm reading this from. Third bullet down, intent to files provide 1 year for the claimant to formalize the claim. That means that if they submit an intent to file today, and today's January 23rd, they have until January 23rd of next year. That's it. If they come back and they file January 24th, and they go, well, I was only 1 day late, that intent to file is no longer valid. It's expired, and the VA will not grant any. They won't grant that form, so they'll lose that whole year of effectiveness. Okay. Okay, so just real quick, any questions on the power of attorney section? No questions? Okay, we'll go ahead and move on. If you do, type it in there and I'll try to get to it after the second portion. Okay, principles of service connection. Okay, there are several principles of service connection. The first one is direct service connection, right? Direct service connection means that it's directly related to your military service, meaning, right? And this is what it requires, meaning there was an injury that occurred while you were on active duty, not the reserves, unless there's a line of duty injury in the reserves, but active duty, all right, that is noted in your service treatment records. Okay, noted. It has to be documented. Okay. Secondly, there needs to be a current diagnosis, meaning you have a current disability that's been diagnosed and you're getting treatment through, whether it's VA or a private doctor currently. All right. And the last thing that's needed for a direct service connection is a medical opinion letter. It's also called a nexus. Okay. The nexus or medical opinion links the current diagnosis to the injury or event that happened while you were in the military. Okay, so these three things must be present. If you don't have any evidence of the in-service injury, or you never got it documented, never went to medical, it's almost like like the injury never existed. If you think about it, you have no evidence to show that it actually happened. And I know a lot of you guys are thinking, well, back in my day, we didn't complain and we didn't do that. I hear you. We hear that all the time. It's unfortunate, but the only thing we can do is you can still file a claim, but if the VA can't find any evidence of that injury, most likely it will get denied. You can try and supplement it with a buddy letter or a witness statement. Obviously your statement, but that's all you really have to work with when filing a claim that you don't have any evidence of while you were in service. Some jobs might be the cause of it, and you can file it as that, but you'll still need your medical opinion letter to explain how your job duties. So I'll give you an example. If you were an admin guy for 20 years, you probably did a lot of typing, a lot of paperwork with your hands or being on a computer. So you develop carpal tunnel in your hands. There could be a link, but your doctor has to be the one that links that to your military service, right? And he has to rule out any other issues. So aggravation. Aggravation means that you had a pre-existing injury, okay? Meaning something that occurred prior to your military service. So you injured your knee, had surgery on it, and you came into the military. So it's a pre-existing injury. Now, the only way that can be service connected if there's evidence that it was made worse because of your military duty, okay? Not due to its natural progression. So if the doctor says, no, well, obviously an injury like that over time will end up to where it's at now, just naturally, then that's not going to help your case. It needs to be shown that through your military duty, it was the reason. Okay. So just because you had an injury or disease that worsened during the military does not mean that it should be service connected. It has to show that the increase in the disability was not due to the natural progression of the disease. All right, sorry here, lost myself. Okay. Presumptive service connection. The basic requirements and explanations for presumptive service connection can be found in 38 CFR 3.307. Okay. It's going to give you, 38 CFR gives you a whole list of diseases. All right. And under 3.309, you'll find the chronic diseases within 12 months of separation, all right, from active duty, usually within 1 year. Okay, tropical diseases, issues that can be service connected for former POWs, herbicides, currently boots on ground and brown water. All right, claims, oh, let me go back real quick. So also the herbicides, so Agent Orange. In 2020, the VA obviously Congress passed the Blue Water Navy law. So now if you're within 12 nautical miles of Vietnam and your ship is found in the logs of being within that area and you've developed a Agent Orange presumptive disease from the list, you may also be eligible. So not only just boots on ground and brown water, it also includes Blue Water Navy as well. If you don't know whether the veteran's ship was near or around there, file the claim. Let the VA do their investigation and decide for the veteran to see. They will let him know whether his ship was within those areas or not. Claims based on exposure to ionizing radiation and diseases. Non-Hodgkin's lymphoma is a presumptive of Blue Water Navy. claims based on chronic effects of exposure to mustard gas, compensation for certain disabilities occurring in the Persian Gulf, veterans, such as undiagnosed illnesses and infectious diseases, can be found in 38 CFR 3.317. And then presumptive service connection for ALS and Lou Gehrig's disease. And there's no timeframes for that. Presumptive condition, basic requirements. One, you need to have confirmed exposure to whatever presumptive that the veteran is filing for exposure to. So if you said you were exposed to Agent Orange, there needs to be evidence of that in your record, whether you were boots on ground or, well, they don't need to be evidence. You just need to show evidence that you were boots on ground, that you were in the blue waters, something like that. We do get some veterans that file claims for, I worked around solvents and diesel, and I was exposed to that, and that was the cause of my disability. Well, then a doctor is going to need to be able to confirm that that specific exposure and that you all should have obviously exposed to it, that's the cause of your disability. The VA will try to confirm your exposure through your personnel record and through your branch of service. They do their research. And then you'll need a confirmed diagnosis of a presumptive condition that is on a presumptive list for that specific exposure. Secondary service-connected disabilities. 38 CFR 3.310, disabilities that are approximately due or aggravated by a service-connected injury or disease. What this means is if you have, give an example, a bad back, you have your service connected for your back at 10%. And because of your back disability that your service connected for at 10%, you start to develop lower extremity in your legs, sciatica or radiculopathy of your lower extremities. And your doctor says that that's why you got it. That's a secondary service connected disability that you may be eligible for. So you would want to file a claim for numbness and tingling of your feet or your legs or sciatica secondary to your lower back. So in order to file for it, again, you have to have a service-connected disability. That's your primary condition, right? You have to have a current diagnosis of the secondary condition, okay? And then obviously the medical opinion letter linking your current diagnosis to your service-connected disability. (38 CFR 3.310) cardiovascular diseases. Ischemic heart disease or other cardiovascular diseases developing in a veteran who has a service-connected amputation of one lower extremity at or above the knee, or service-connected amputations of both lower extremities at or above the ankles shall be held to be the proximate result of the service-connected amputation or amputations. So a lot of times because they amputate a leg, and you know, obviously you have a heart condition, or you know, then they because of the lack of circulation now through your body, or the reduced circulation in your body, you know, you develop those secondary issues. You can also get those service connected, okay, especially if they have to amputate it because of your heart conditions. TBI in a veteran who has a service-connected traumatic brain injury, the following shall be held to be the proximate result of the service-connected traumatic brain injury in the absence of clear evidence to the contrary. Parkinsonism, including Parkinson's disease, following moderate or severe TBI. Unprovoked seizures following moderate or severe TBI. So these are secondary issues relating to your TBI, traumatic brain injury. Continuing on the TBI, dementias, if manifested within 15 years following moderate or severe traumatic brain injury. Depression, if manifested within 3 years of the moderate or severe TBI, or within 12 months of mild TBI. Diseases or hormones deficiency that result from, oh, that's a good one, thalamo pituitary changes if manifest within 12 months of moderate or severe TBI. Disabilities due to a VA hospital care or VA treatment, also referred to as an 1151 claim. Okay, this usually means that it was negligent care, or because of the VA caused this disability while you were in their hospital care or their treatment or their care. If it is determined that there is an additional disability resulting from a disease or injury or aggravation of an existing injury, or if injury suffered as a result of hospitalization, medical or surgical treatment or examination, compensation will be payable for such additional disability. If you went to the VA hospital, and so as an example, if you went to the VA hospital and they're changing you beds and they lift you up, they drop you and you break an arm, you could possibly file for that broken arm. Disability due to training and rehabilitation or compensation or compensated work therapy, CWT program. To establish that the provision of training and rehabilitation services or a CWT program approximately caused a veteran's additional disability or death, it must be shown that the veteran's participation in an essential activity or function of the training, services, or CWT program provided or authorized by VA approximately caused the disability or death. So I believe like if you were like on a type of woke rehab and while you were engaged in woke rehab activities, you suffer an injury, you may be able to file for that disability. But again, there needs to be one, that activity must have been authorized through the program by the VA. And if it was authorized and you were caused a disability or passed away, then they may grant service connection. Paired organs and extremities. Compensation is payable for the combinations of service-connected and non-service-connected disabilities, as if both disabilities were service-connected, provided the non-service-connected disability is not the result of the veteran's own willful misconduct. Impairment of vision in one eye as a result of service-connected disability and the impairment of vision in the other eye as a result of non-service-connected disability. Loss or loss of use of one kidney as a result of service-connected disability and involvement of the other kidney as a result of non-service-connected disability. Hearing impairment in one ear compensable to a degree of 10% or more, service-connected, and a hearing impairment not service-connected in the other ear that meets the provisions of 3.385 in the other ear. So you still have to meet the criteria for hearing loss in the other ear. A lot of people go, oh, well, I can't hear out of the ear very well. They'll do the hearing exam. If during the hearing exam, the exam doesn't conclude that you have significant hearing loss that meets the criteria of 3.385, then they will not grant. Loss or loss of use of one hand or more or one foot as a result of a service-connected disability, and loss of use of the other hand or foot as a result of non-service-connected disability. Permanent service-connected disabilities of one lung rated 50% or more disabling in combination with the non-service-connected disability of the other lung. Any questions on the principles of service connection? Again, just to reiterate what they were, there's 7 ways to be service connected. One is direct. The other one is aggravation of a pre-existing injury. All right. The other one is a presumptive. Okay. And the other one is secondary. Then we have 1151, which is hospitalization or negligent care under the VA. Paired organs. And then lastly, training, disability due to training and rehabilitation services. See if I have any questions. No questions up on the above. Okay. So let me see where we're at right now. Okay. Claims process basics, evidence, effective dates, and service connection. Claims process. DSO and CSOs meet with claimant to file a claim. Can always consider the intent to file, ITF, with all POAs. DSO and CSO submits claim to NSO office. We review it. The NSO office reviews the claim and we submit it to the VA. The VA will then receive the claim and establish a claim in a tracking system. So they'll put it in there. The veteran usually gets a notification about 3 or 4 weeks from the date that we submit the claim to the address that was on that application, letting them know that they've received the claim and that they're working on it. So that's kind of like the notice that, hey, we got it and it's being worked on. And then the VA starts to develop the claim. So they have a duty to assist. They let them know that they've received the claim, any evidence that they might need to submit or that they can submit. If they have a private doctor that's not through the VA will send them forms, letting them know, hey, this form will allow us to request that information from private doctors if you have it. And then they will also conduct the VA examinations, but not on all claims. Then the VA completes all development of the claim and goes to the rating service representative. And then the rating representative, the service representative, renders a decision, and the decision is reviewed by an NSO. So usually whenever decisions are made, we review them on a daily basis. They come into our office and they go, hey, this veteran's claim is complete. This is what we decided. We review it for any errors that might be seen. And then we go, okay, if it's good, then we tell the VA it's good to go. And then the VA notifies the claimant in writing after that. And then if any compensation is due, they'll pay it out to the claimant. Assisting in the claims process. Types of evidence helpful for claims. Obviously, medical treatment reports, whether they're from service or private, are obviously important. DBQs. Now, I want to talk a little bit about this DBQ part. DBQs, I believe it was last year, right before the pandemic, they took them off the website. So DBQs are no longer on the VA website. And the VA says that they're no longer taking them. Now, if a veteran gets a DBQ from somewhere and they submit it, they can still submit it as evidence. They just got to make sure that it's filled out by the doctor and not by the veteran. Okay. But just because they submitted a DBQ or the disability benefit questionnaire doesn't mean that the VA is not going to call them in for an exam. So they still got to be prepared to go in for a VA examination if so needed. Medical doctor statements, lay statements, also known as buddy letters, your military records. So those are the types of things that you can submit that that the VA will consider in regards to your claim. And a lay statement can also be your statement or your wife's statement. So. Any questions on the claims process for VA purposes?
Hey, real quick, Carlos. In those lay statements are powerful as long as we play our position as a lay person. They lose their power as soon as the buddy tries to highlight the doctor. So if it's in support of your sleep apnea, he's not saying I was with him in service and he has sleep apnea in service. He's just giving a description. So he's talking about how, when we slept in the same tent together, I'm trying to get to sleep before he gets to sleep. Well, I'm going to be up all night. I'm just snoring. This dude would stop breathing. He's getting crap out of me. I would kick his rack to wake him up. Then I noticed he would stop breathing.
You're all garbled right now.
And the other thing is daytime insomnia. So he's the only guy who I know who could fall asleep standing up during the meeting. So I did like a 10-year-old kid, not a doctor.
Hey, Lee.
Yes.
Hey, we can't really hear you coming up all stuff.
Hey, let me grab my mic.
Can you guys hear me okay?
Yes.
Okay. Sorry, Lee. Hopefully, you can get your comms fixed, and then you can we can always touch back on that part. Okay, there's a question on here that says, "Can you give us some information on the Fort McKinley
Radio check over.
Still the same, Lee. Presumptive conditions. Don't know of any in Fort McKinley. So I would refer to the va.gov website to see if there's anything there. But because they'll tell you what bases, what locations have presumptive conditions, and they'll give you a list. All right. So moving on to the effective dates. All right. Except as otherwise provided, the effective date of an evaluation and award of pension, compensation, or dependency and indemnity compensation based on an original claim, a claim reopened after a final disallowance, or a claim for increase will be the date of receipt of the claim or the date entitlement arose, whichever is later. And that's based on the 38 CFR 3.400. Okay, so we have times where veterans will go, well, I didn't know. No one told me, this information wasn't available to us back then. And again, it's unfortunate that the communication was disseminated back then, but it's going to go from the date of the claim or the date the entitlement arose. Now, that's just something to keep in mind. Protection rule, 10 years, service connection, and this will be found on 38 CFR 3.957. Service connection for any disability or death granted or continued under Title 38 USC, which means it has been in effect for 10 or more years, will not be severed, except upon a showing that the original grant was based on fraud, or it is clearly shown from military records that the person concerned did not have the requisite service or character of discharge. So it cannot be severed after 10 years, but it can be reduced, meaning you're at 10 years and you have PTSD at 70%. You file for an increase, they can't take it away, but they can reduce it to 50 or 30. Okay, that's an example. 20 years. 20 years evaluation of disability. 38 CFR 3.951. A disability which has been continuously rated at or above any evaluation of disability for 20 or more years for compensation purposes under laws administered by the Department of Veterans Affairs will not be reduced to less than such evaluation, except upon a showing that such rating was based on fraud. So after 20 years, your disability is static, so it can still continue to go up, but it can't go any lower than what you were last rated at for those last 20 years. So if you were at 50% for 70% for PTSD for 20 years, you file an increase because you want to try to get to that 100% for PTSD, and they go, nope. Then the lowest it can go to is 70% because you've had it for 20 years or more.
Can you hear me now?
Go again, Lee?
Can you hear me now?
Nope, still sounding the same. Okay, keys to service connection, new and material evidence, reopened claim, right? So this would kind of fall under the 38 CFR 3.156. A claimant may reopen a finally adjudicated claim by submitting new and material evidence more than a year since the previous decision. So usually we use the supplemental review, if you guys remember that from the yesterday, the VA form 20-0995. That's the form that we use to file a claim to reopen a claim that has been previously decided, even if it's been more than a year since that claim. New and material evidence means existing evidence that by itself or when considered with previous evidence of record, meaning the VA already had it in their system, relates to an unestablished fact necessary to substantiate the claim. Okay, so new material, just if you submitted a nexus letter from your doctor that links your acid reflux to your military service and it was denied, and then you just submitted another letter by a different doctor that says the same thing, that's not new and material. That's just the same thing being reworded by somebody else. So new and material is meaning something that they didn't have in the record before.
Juan, can you hear me now?
Nope, still the same, Lee. New and material evidence continued here. New evidence means not previously of record, meaning the VA has never had it in their possession or it's never been reviewed. Material relates to a previously unestablished fact and raises the possibility of sustaining the claim. Meaning, if the VA sent you a letter that says, hey, you're denied for service connection for your sleep apnea because we did not find a link between your military service and the condition, then that basically telling you that you're missing a nexus letter. If you submit a nexus letter, that letter raises a possibility of sustaining the claim if it explains how your sleep apnea is in fact related to your military service. Okay. Nope, still the same, Lee. Keys to service connection, medical opinions. Again, same thing on nexus letter, okay? Review of private medical records and service treatment records must be mentioned. We get a lot of nexus letters from veterans that submit with their claims where the doctor just says the veteran's lower back is related to his military service. And that's it. If you have any questions, call me. And they sign in, they give their information. That's not a nexus letter. That doesn't explain medically, right, how they're linked, right? It doesn't give a rationale as to how the doctor came to that opinion. So it needs to be explained. If not, the VA will try to get one of their doctors to look into it, but obviously we want to submit evidence that's going to be productive to the veteran's claim. So don't be afraid to tell them, you know what, it's missing some information, we'll submit it, but try to get another letter from your doctor. Okay, don't ever say, I'm not going to submit this because it's no good. No, because we're not the ones that make the decision. Just go ahead, well, I'm going to submit it, but just letting you know, it's missing some meat and potatoes and explaining how your back was caused by that injury when you were in the military. So they can try and get another one. All right, timeframes. Timeframes within 1 year, new and material evidence can be used to re-adjudicate for re-adjudication. After 1 year, the claim will be considered claim to reopen. So what that means is if within 1 year of the claim of that decision, let's say it was denied, you submit, it was denied because there was no link, and you submit a nexus letter, there could be, they could go back to the original date of that claim. After 1 year, it's going to go from the date of that you reopened it, that you submitted that new evidence. And then we talk about the effective dates, date of claim to reopen. Okay, the next session is standardized forms and fully developed claims and appeals and modernization act. At this time, I would like to see if anybody has any questions on what we've covered so far, so we don't get too far ahead. Anybody have any questions in the topics that we've discussed so far?
Yes, Richard Gayton for chapter 26, Modesto. I have on the original date on CFR 38156. If you were diagnosed with, especially with veterans with PTSD, and they were diagnosed earlier with diabetes and got denied, now you get a re-evaluation saying that you did have diabetes. Now, can you use the first reopen claim, or do you have to be the claim started the one when they decide you had diabetes?
I'm sorry, let me understand this question correctly. You said you initially applied for diabetes and it was denied. And then you submit to reopen it with evidence showing that you do have diabetes?
Yes.
If it's within 1 year of that claim, then they could go back to the date that you initially filed it, if it's within 1 year. If it's after 1 year, then they'll go from the date of the reopened claim.
Okay. Well, why don't they go under, because it's presumption that, like all Agent Orange.
Okay, so that's a different topic. So if
Okay.
it's related to your presumptive, meaning, let's say, if you obviously, I'll give the example of what's going on now with Blue Water veterans. Those veterans had filed for a lot of the Agent Orange conditions, and they were being denied, right? But now
Right.
that the law changed, if they file a claim to reopen it, the VA is looking to go back to the date that they initially had filed. So some of these veterans are seeing retroactive payments for that, but that's only on a case-by-case basis for presumptive conditions.
Okay. Thank you.
Yes, sir. Any other questions?
Yes. Can you hear me?
Yes, sir.
I'm having trouble with my screen. I have the forms come up, but I don't have your picture.
You can see the slides though.
Yes.
Okay, that's all you gotta see. You don't want to see my ugly face, no. Don't worry about my ugly face. You want to see the form.
It didn't look that bad. Okay, thank you very much.
Yes, sir. All right. Well, yes.
Can you hear me?
No, you're still the same, standing scrabbled up.
It's gonna be a long day.
Yeah. Okay. So at this time, it's about 10 minutes till 1. If you have questions, I'll be on here till 1300 answering your questions that you type in there. And then we'll do a 15-minute break, and we'll come back at 13:05. Okay, 13:05 to or 1:05 to continue the training for standardized forms and fully developed claims in the Appeals Modernization Act. Okay, guys, so go ahead and take a break at this time.
You want to come back at 1 o'clock? Yeah, I can go to 1.
You guys don't forget to mute your screens and your computers so there's no background noise in case some people have questions. Richard Valdez says, another example regarding new and material evidence is when the claims adjudicator did not use information submitted with the claim. It's important vets review